All right, Yana, you want to kick us off?
Sure. So I see here we have 70 participants and counting. People are still joining us here, but I'll make a brief introduction. We have Jeremy Baker here with Baker Law. He has been providing us advice and doing lunch and learn lectures with the AAA for a couple of years now. Jeremy was 13 years with Schiff and Harden. He was a partner there and member of their construction law group. And he has worked with many of you, I would assume. He supports various firms here within the Chicago area. And he was very generous to offer us today the discussion about mechanical liens and how to get paid. I'm sure that's a topic that's on the minds of all of us here, especially in the leadership roles in the various companies. And hopefully we can hear some good advice how to navigate through this time where obviously everybody is struggling, not only on our side architecturally, but also on our client side. So with that being said, Jeremy, I'll give it over to you.
Thanks a lot, Yana. Before we get started, since nobody likes to think about lawyers and law in rough economic times, I wanted to start off with something a little fun. And I was curious whether any of the aesthetically minded people who are on this call might be able to tell what the inspiration for my logo was. If you have a sense for it, you shoot me an email, and my email address is below. I will send you a Starbucks gift card. So we'll see whether I outsmarted myself or whether there's actually something that people can recognize in there. So briefly, I didn't know that I was going to be on video. So I put a picture of myself here. It's the only time you'll probably ever see me in a suit. And when I'm not playing a lawyer, I'm usually playing music, playing with my kids, and playing amateur astronomer. For those of you who can see on the screen, I'm getting to spend a lot more time with my telescope, which is right behind me in my home office here, than when I am in my office, downtown Chicago. So that is actually not a prop for this presentation. It's actually something that sits in my office so I can keep my kids away from it. But really what I am is a lawyer for architects and engineers. I don't really represent many contractors. I do represent owners and developers, as well as design professionals. And this is one of the rare times when I'm going to be talking about making claims, because even though I've litigated my entire career, I'm really about helping architects and engineers into good contracts that help them stay out of disputes. One of the things I'm most proud of is that I'm a liaison to the AIA Contract Documents Committee, which is a fancy way of saying that when the really smart people on the Contract Documents Committee prepare the new AIA contracts, I occasionally get to weigh in and put my 2 cents in while the drafts are being prepared. I have been practicing law for a while in Chicago. I am going on 18 years. And most all of those 18 years, with the exception of the last 6 months, I worked in big law firms. For most of the last 14 years, I was with Schiff Harden and their construction law group, where I was a partner. And I launched my firm about 6 months ago for a number of reasons, but part of those reasons are that I think that architects are underserved by lawyers, because you usually don't get counsel unless you are in a claim situation. And I really would like to try to be an option for design professionals to help them get into good contracts and stay out of trouble and get paid. And so I would love to hear from any of you in the future if there's anything that I can do to help you. So what are we going to talk about today? Well, the first part's the boring part. What are liens? We're going to cover that because I suspect that some of you have heard of them but don't really know what they are. And then we're going to talk about why mechanics liens are really important in this strange time that we're in right now. And since I know that this is not just a dry topic that you have an academic interest in, that you have real questions and real problems, I'm going to try to get real practical at the end of this and talk about what are the pros and cons you might want to consider as you think about making lien claims or not, as we as professional service providers try to ensure that we get paid. And, you know, what's the process for making lien claims, and, you know, what is the cost? Obviously, it's something that's very important to us all in these difficult economic times. I did want to start off with a few words of caution. Number one, this presentation is geared towards Illinois law. So if you are in another state right now, you might want to think about getting off the call. Lien laws are very state specific. I've been involved with hundreds of liens in Illinois, but if somebody asked me to put a lien on a property in Wisconsin or Indiana or Michigan, I'd say find another lawyer. So, you know, if you're not in Illinois, you might want to think about whether or not this is a good topic for you. And there are kinds of liens that can be put on public projects, and then there are liens that are on private projects. And this particular presentation is really geared for private projects that are privately owned, not government projects. And one of the things that I really want to try to get across here, without delving into all of the stuff that will bore you, is just how intensely complex mechanics lien law is. You know, in my almost 18 years of practice, I think that mechanics lien law is up there with critical path scheduling and certain kinds of construction cost accounting as the most complicated thing that I've encountered. People think of mechanics liens as a piece of paper with some words on it, and on some level that's true. But the law behind getting the words right and getting the process right is among the most complicated things that I've encountered. So I'm not going to bore you with all those details, but just to let you know that we're not talking about just filling out a simple form here. And if any of you have concerns on condominium projects, I would urge you more than anybody else to not sit on your hands for a few months. Condominium projects present the most complicated difficulties with mechanics liens. And if you're concerned about payment on a condo project, you're probably going to want to get proactive much more quickly than if you are on another kind of project. You should know that mechanics liens have short deadlines to take action, and those deadlines are triggered by your last date of work. And there are lots of fights in the law about what is enough work to reset the clock. Lots of times people want to go back and take one final look at the punch list, or contractors go back to pick up some tools, and there's lots of fights over whether that amount of work is enough to restart the clock. And so if you have a project that's slowed down and you're not doing substantial work, you may be already well into your deadlines to take action. So you should be cognizant of the fact that this is something that you might need to think about more in the span of days or weeks than months. I'm going to talk about some of the unique challenges that are presented by the fact that law firms and title insurers and recorders of deeds offices are closed down right now, which makes it much harder for us to operate and get liens on projects when we decide that it's in our client's strategic interest to do so. And really, this presentation is meant to provoke thought. I'm not trying to give you specific legal advice here, because in the law of mechanics liens, every rule has got an exception, and every exception has an exception. And so there's not a lot of specific detail that I want to give you, because I don't want you to go and try to apply it to your own facts, reach the wrong conclusions, and then say, geez, I got the wrong idea from Jeremy. So none of this is intended to be legal advice for you. It's meant to provoke thoughts. And so this is the most boring slide we're going to cover, but it seems like a pretty important one. What is a mechanics lien exactly? And the closest analogy that I can draw is to a mortgage. Mechanics liens are a lot like mortgages. A mechanics lien is a claim for payment, and you physically attach it to real property. And what you do in order to make that claim is you record a document in the real estate records, in the real property records, in the same place that lenders record mortgages. And once you successfully are able to assert your lien claim and get it recorded, the lien is attached to the real property, and it becomes secured by the value of the property. So let's stop for a moment and think about what that means. We all know that a lot of real estate developers develop projects using single purpose entities, LLCs, that are shell companies. They have no assets. And so if you assert a claim for breach of contract, you didn't get paid by a developer that is using a single purpose entity, an LLC, you might win your lawsuit and get a verdict that is worth less than the paper it's written on, right? Because there's no money there. There's no pot of gold at the end of the rainbow. But when you attach your claim for payment to the real property by recording your lien, you're actually securitizing your claim for payment with something of value. And what you can do, if push comes to shove, is you can file a lawsuit to foreclose your mechanics lien, just like lenders file lawsuits to foreclose their mortgages. And whether it's a lien foreclosure action or a mortgage foreclosure action, courts will conduct a judicial sale. The court will literally sell the property out from under the owner, and they will take the proceeds of the sale and they will distribute those proceeds to the various people that have claims against the property, the lien claimants, the lenders that have their mortgages. And if there's not enough value from the sale to satisfy all of the people's claims, the court passes out the money based upon the relative priority of the parties. There's literally a pecking order. Who gets paid with first dollars, who gets paid with second. And that's one of the reasons for there being short deadlines, is that in order for you to make sure that you get the best priority, you have to take action quickly. Otherwise, you could find yourself stuck in line behind a lender that's got a $10 million mortgage, and you could have a great lien claim and you could win, but at the end of the day, there might be no money available for you. And I wanted to put in caps at the bottom of this slide that in most instances, it's not necessary to file suit. Nobody likes to file suit. I'm not the kind of lawyer that is stirring up litigation. I think litigation is a cancer on our society, and I do everything that I can to avoid it for my design professional clients and others. And so I don't want you to get the idea that if you record a lien claim, it necessarily means that you have to go try to sell your client's property. Now, the reason that liens can be valuable for securing payment is that they create problems for project owners and project lenders. So let's review some of those problems real quick. If your developer client, or if your property owner client is financing construction, or even just has any sort of a loan where there's a mortgage on the property, the lender is not going to like to see mechanics lien claims, because the deal that your clients, the property owners and developers, strike with their lender is that they're going to keep the lien claims off the property. And so every month when the title insurer process and the draw process on construction projects happens, the lenders and the title insurers are looking at what claims have been reported against the property. So your clients are likely to see your lien claim pretty quickly, and oftentimes get pressured by lenders to deal with the lien claims. I won't get into this too much because it's pretty boring, but we all know about lien waivers and sworn statements, and that really speaks to the second bullet point here, is that if owners and developers don't do the payment process right, they can run the risk of having to pay for the same work twice. So that's the reason why every month they're looking at lien waivers and sworn statements, is they want to avoid the risk of having to pay for the same work twice, and that's something that happens when there are lien claims under certain circumstances. And one of the real things that's powerful here for lien claimants is that if you do not have a contract with the property owner, if you are an engineering subconsultant, for example, that's hired by an architect, you're probably not going to be able to make a claim directly against the owner unless you assert a mechanics lien claim. Lower tier consultants that don't have contracts directly with the project owner can make claims directly against the owner and against the property value in instances where they otherwise wouldn't be able to. So that's something that owners don't like to see, and it's important. It's an important power that the Lien Act gives to people who are lien claimants. Liens also create problems for lenders, and this is one of the reasons that they put pressure on real estate developers and property owners to take care of lien claims, to get them settled. And the Lien Act, in many respects, favors architects and engineers and contractors. It favors the claimant, because under Illinois law, there are some circumstances where you can record a lien after the lender recorded their mortgage, and you can leapfrog ahead of the lender in terms of priority. You can take sale proceeds before the lender, which is a way of saying that the security that they have in the property gets diluted by your lien claims. Let's think about this in a simple example. A lot of people are refinancing the mortgages on their homes right now. What happens? The lender sends out an appraiser to your house to eyeball your house, to walk through. What are they doing? They're trying to make sure that there's enough value in your property that if you don't pay, they're going to take your property away from you in a foreclosure action, and they're going to get their money back. Okay, so what happens if a lender makes a loan on the assumption that the property has all this value, but then you as an architect or an engineer sneaks in with your lien claim and is able to jump ahead of them in terms of priority? They now have had the assumptions on which they made their loan completely upset. There may not be sufficient value for them if the owner doesn't pay and they need to foreclose, because you might have gotten ahead of them in priority and you might be first in line to get paid. And even if you don't have priority, you can still trigger a lawsuit that would make everybody participate. So liens are bad for lenders, they're bad for owners, they're bad for title insurers, and they're no panacea. And I'm going to talk about a lot of the downsides to reporting liens in the future, next slides. But it probably is the least expensive way for you to gain maximum leverage over the people that have the ability to pay you. So why is this also complicated? You know, I've said that lien law is extremely complicated, and it's because the Lien Act's not just about you getting paid. The Lien Act beautifully compromises and balances a lot of different people's interests. If a lender is going to think about making a loan, they have to be able to look at the property records and know whether or not lien claims are coming. And if 90 days or 4 months or whatever the deadline is passes between when somebody is working on the project and not, a lender is going to say, okay, there's no lien claim recorded, now I'm in the clear, I can make my loan. If you're some sort of an investor and you're thinking about putting money into a project, you are equally interested in looking at the title records and being able to make a prediction about whether or not it is too late for somebody to make a lien claim. If you're an owner, you know, you do not want to, be stuck with double payment. You don't want to be stuck with lien claims that you can't anticipate. And the same goes for tenants. And they're going to need to be able to look at the property records and make some judgments about what the risk is. And that's why, you know, people have short time frames to take action. And in many instances, it's not possible to amend the lien once it's recorded, because by then somebody might have relied on what they saw on the property records. Same thing goes with a purchaser. If you're thinking about buying a piece of property, you don't want to be surprised to become the new owner of the property that gets whacked with a lot of mechanics liens. And then of course there are considerations for the title insurers and people like yourself, architects and consultants. And so if you think about the lien process as something just to get you paid, you're looking at it in a very myopic way. It is a balancing act of a lot of people's interests. And that's why you got to get your lien claims on the property right, and you got to get them on timely in order to get favorable treatment under the Lien Act. Because really, you know, if you think about this from a standpoint of fairness, and you think, I do good work, I'm a good design professional, I'm honest with my clients, you know, I've helped them, maybe I've taken a hit financially, I've written off some additional services I've not charged them for, of course the law is going to help me. You're looking at it in a really naive way, because in many instances, there isn't enough value in the property to satisfy all of the people that have claims. And somebody is going to get the short end of the stick, okay? And the Lien Act and mechanics liens are not about fairness, they're about predictability. There's a famous quote that people say on the first day of law school, that if you want justice, you should go to the theology school up the street, because the law is not about fairness or justice, it's about predictability. So if you are out there right now and you are thinking about, am I going to get paid on that project where maybe the developer's a little bit late, and you think that the courts are going to save you because you're a good guy or a good gal, you're making a big mistake, because the law doesn't care about fairness. The law cares about predictability. And what you can do to have a good outcome is to create for yourself a good set of facts. Have good contracts. Don't let your AR run out too far. If you're going to record a lien, make sure you get it right. Make sure you get it on the project in a timely way. So before we talk about some of the other mechanics, I want to talk about pros and cons, because some of you are probably out there struggling with, I don't know what a lien is. I don't necessarily have a lot of cash right now to hire a lawyer. I've never made a lien claim in my life. Should I even be thinking about this? And if you're somewhere at the intersection of procrastination and homework, I want to kind of give you some practical thoughts on this. One thing is that it's a great way to get paid. I mean, the truth is that if you record a lien, the lenders and title insurers and the owners and developers of your project are going to know pretty quick. And in many instances, when I represent architects that lien projects, we'll even send it to them right after we record it with a conciliatory letter that says, look, this is not aggressive action. We love you. We love this project. We're committed to seeing it done. But no prudent business owner would sleep on these deadlines. So we hope that you understand that this is just business. And most sophisticated developers and real estate developers and property owners understand that. And they just view it as business. Again, if you do not have a contract with the owner, if you are a lower tier party, a subconsultant, you all of a sudden can have a direct claim against the owner if you make a mechanics lien claim, which is a big plus, especially if you are an engineering subconsultant that gets a lot of work from an architect that hired you. You know the architect is cash strapped. You know the architect is thinking about making payroll. You don't know if they're going to be able to pay you. This is a way for a lower tier party to have a claim against potentially the deep pocket real estate developer or property owner. I talked a little bit earlier about the difference between a secured claim and an unsecured claim. Your breach of contract action against a single purpose LLC that has no assets is basically worthless. But your winning mechanics lien claim against a piece of property that has value is much more worthwhile. Your claim has become secured. And there's also bankruptcy court implications here, because when you have developers or property owners that go up into bankruptcy, what the courts will often do is they will divide up all the claimants into those who have secured claims and those who have unsecured claims. And those with secured claims tend to get 75 cents on the dollar or 60 cents on the dollar or something like that. Unsecured claimants might get 10 cents on the dollar. So if you make a mechanics lien claim and your client goes belly up, you're able to, in many instances, put yourself in a much more favorable class of claimants and receive more favorable treatment from bankruptcy courts. Another thing is that unlike many other states and unlike on public projects where you've got short deadlines to file suit, typically if you record a mechanics lien claim, it's valid for 2 years from your last date of work. And so in many instances, you can record a lien claim and let it sit out there and ride out the turbulent economic times and maybe get paid in 6 months or 9 months. And something that might scare the architects that are in contract with the owners directly is the last pro on the bottom side right there, is that in most instances, if you're an architect, let's say that you're owed $1 million by your developer owner client, and half of that you owe to engineering subconsultants, your engineering subconsultants probably have a valid breach of contract claim against you regardless of whether or not you get paid. So if you're an architect that's owed a lot of money out there, or if you're the lead design professional happens to be an engineer and you're in direct contract with the owner with subconsultants under you, you really want to maybe think about securing your claims for payment, because your subconsultants may have very valid, very scary breach of contract claims against you that they can assert regardless of whether or not you ultimately get paid. Just stepping back and trying to be practical here, I represent a lot of owners and developers, and the squeaky wheel tends to get the grease. If there's 20, 25 subcontractors on a project and I represent the owner, I represent the developer, believe me, when a lien claim is recorded, I know exactly who are the ones that are reporting those lien claims, and they're the subject of discussion. Many other people that sleep on their deadlines get pushed aside. And, if you sleep on your deadlines and you allow your deadline to pass, that's really a signal to your owner or developer clients that you're not serious about getting paid. So while lien claims are no panacea, and many times I've seen lien claimants wish they never went down that road in the first place, if you want to send a signal that you're serious, and you're willing to part with a little bit of money to get a lawyer to get the lien on the property now, if you feel that that's a worthwhile investment, you're probably going to put yourself in the class of people involved in the project that the owner, developer, lender, title insurer are going to look at as more of a problem and more likely to get paid, because the squeaky wheel gets the grease. There are a lot of cons. There's expense associated with this. There's hassle associated with this. The last 2 mechanics liens that I recorded took me anywhere from 8 to 15 hours to record, because I've litigated enough of these things that I know, based on the eccentricities of the property records and the project and the deal and who I'm up against, whether or not I'm going to get a fire-breathing lawyer on the other side that's really going to fight me and try to point out problems with the document that I prepared. And I work hard to make sure that when I record a lien, I don't give any opportunities for somebody to defend against the claim based on some mistake in the document. So I spend a lot of time making sure I get it right. So there is a certain amount of expense involved in this. And anytime you got to talk to a lawyer, you're going to feel hassled. I know that lawyers are not the favorites of many people, and certainly design professionals are in that category. And you might anger your clients. I mean, look, if I had a nickel for every time I had a developer call up my design professional client and say, look, if you record your lien, you're going to blow this project up and I'm going to get foreclosed on and you're not going to get paid, I'd be a very rich man. And lien claimants get a lot of pressure from their clients to not bring these kind of claims. And you might anger your clients, but you know what I got to say to that, to be perfectly honest, who cares? What prudent business owner that otherwise decides that they have the wherewithal and it's in their interest to record a lien claim is going to allow their rights to pass because they might get an angry phone call from their client? You know what? Business is business. And when I went out on my own, somebody said something to me that really resonated with me. There was a question that somebody asked, what as a lawyer is your number one priority? And some people said, oh, it's doing good work. It's dispensing justice, it's pro bono, and those things are all really important. But I think that the correct answer is actually number one priority is getting paid. Because if you're going to take care of your employees and you're going to take care, of the people that you owe money, you have to be in business. If you're going to take care of your family, you have to be in business. So I think as a fellow professional service provider, I think that getting paid is very important, and it's something that should be a priority for all of you. And I'm not sure that I would let my clients dissuade me from making a claim that would increase the chances of getting me paid because of some argument that, oh, it's going to be trouble for me. It's just business. Also, liens sometimes lead to litigation, because if 10 liens get put on a piece of property, if one lien claimant forecloses their lien, they got to sue everybody. So you can get dragged into litigation. And that's something that a lot of people don't like. So, if you put a lien on a piece of property, you might get a nasty surprise that you're getting dragged into litigation. You can always very quickly release your lien claim and get out of it. So I don't know that that's the biggest concern, but you can get dragged into litigation. And there really is no guarantee of payment. I would be lying to you if I told you that every time I had a client that recorded a mechanics lien claim, they got paid. There's lots of times that they'll spend the money to get the lien on, and, because their clients are more interested in making payroll or servicing their debt or paying other bills, they're not in any hurry to rush to pay you. And, we're in difficult times right now. That might be what we're faced with. But in many instances, the lien can sit there for a few months and you get paid then. Or in some other instances, people get paid within a week of when they put their lien claim on. You just never know. So with that, I want to talk briefly about what are the requirements for making a mechanics lien claim. And, there are a number of them. This slide's deceptively simple. It's much more complicated than this, but essentially you have to have a valid contract to improve the property. And that can be with the owner, or it can be with, someone that contracted with the owner. If you're an engineer and you don't have a contract with the owner, you can still have a lien claim as long as whoever hired you is a design professional or somebody up above you in the contractual chain that, is authorized by the owner to enter into the contract. And it doesn't necessarily have to be the property owner that hires the top tier person in line for contracts. The owner can authorize or knowingly permit an agent or somebody else to hire the architect, and that's fine. And then the architect can hire the engineering subconsultants. That's all fine too. You have to perform lienable services or work. And in most instances, design services are going to qualify. There's a whole bunch of stuff that doesn't, providing temporary heaters and that sort of thing. Kind of the rule of thumb is that if what you're doing is going to make the property more valuable and it's not something temporary that's going to get taken away, it's probably going to be lienable, although that is also something that is very complicated. And then you have to perform your contract. If you walked off the job or you did a lousy job, you're maybe not going to have a valid claim. If you have a good breach of contract claim for not being paid and there's no defenses against you, and you do everything right under the Lien Act, you've performed your contract, you probably are going to have the ability to make a lien claim. And if you had to stop work because you didn't get paid, then you've got a valid excuse for not performing your contract, and that's just fine too. Again, these are so complicated, these issues that lawyers fight over for years. So I don't want you to think it's quite as simple as this slide looks, but I'm trying to keep it quick and simple. And the other thing is that you have to timely comply with your requirements under the Lien Act. And in many instances, you got to take action within, a month or two, of when you sniff trouble. And you got to get it just right. I mean, strictly complying with the Lien Act, no typos. My newest clients that I literally just signed up 10 minutes ago are developers that are facing lien claims on their property. I looked at the documents that were filed and I was immediately able to see that there are 3 problems with them that are probably going to allow me to avoid those liens. So I like to joke that if you use a semicolon where you're supposed to use a comma in your lien claim, it can be invalid. And I'm being a little facetious there, but not much. If you make any kind of a typo in the way that you describe the property, you describe the contract, you describe what you're owed, anything like that, you could probably get your lien claim on timely and wind up having a lien with no value. So you really have to comply with the Lien Act in order to have a valid lien claim. I won't have many slides like this because it's too much to read, but what I want you to see is that typically speaking, design services are lienable. This is a section, this is part of the Lien Act, and what does it mean to improve the property? To perform any service or incur any expenses an architect, structural engineer, professional engineer, land surveyor, or registered interior designer. So in most instances, I would think that the people who are on this call are going to have provided lienable services. And some of you are probably thinking, what about that abandoned project? What about that project where I got through SD or DD or CDs, and maybe there's even a permit set, but then the project went kaput for one reason or another. You're probably going to be able to make a lien claim. If there was litigation that ensued, there'd be certain complexities that might follow from the fact that the project wasn't built, but I don't think that an abandoned project or a project that gets shelved simply because of hard economic times or for some other reason, that's not necessarily going to knock you out of the box for the ability to bring a lien claim and try to leverage up your negotiating power in an effort to get paid. So what are my deadlines? And here I'm going to be a little bit coy on purpose, and I'm not going to talk about numbers. And it's not because I am trying to, get you guys to hire me or, or anything like that. It's because my greatest fear in this whole presentation is that you are going to take a modicum of knowledge that I give you and you're going to try to apply it to your circumstances. And it's going to be intensely complex, and there's going to be some exception that you're not going to understand. And by the time that you figured out that you blew your deadline, it's going to be too late. So I'm going to give you a certain amount of guidance here, but I don't want to give you enough to try to figure this out in a way that might cause you to blow your deadline. If you are working on a project where it is an owner-occupied single-family residential project, you might have some of the shortest deadlines that are out there. And that is because the law tends to be consumer-oriented. It tends to favor the little guy. And they like to make sure that homeowners, who are probably the least sophisticated consumers of design and construction services, have the most flags waved at them in advance of when a lien claim is put on the project. But when you start dealing with commercial properties, it's a little more forgiving. And then the question becomes, you know, what you see at the bottom of the slide deck here, are you what is considered an original contractor, or are you considered a subcontractor? And I think there's a lot of design professionals on this call right now that are feeling outraged, saying, how dare you call me a contractor or a subcontractor? Well, I got news for you. Under the Lien Act, this is binary. You are either one or the other, right? And you are an original contractor if you have a contract with the owner of the property or with somebody that the owner has knowingly authorized to hire you. If you are lower tier, if you are, you know, on the construction side, a trade contractor under a GC, on the design side, if you are a structural engineer or a mechanical engineer that has been hired by an architect, then you are a subcontractor as far as the Lien Act is considered. And so let's take a look at this chart here real quick, because lawyers love charts, you know, and so what I'm trying to illustrate here is what's the difference? You know, how do you know which of these categories you fall into? All right, and so the lines are contracts, all right, and you can see my laser pointer here, the owner has hired the architect directly, okay? And since this is an AIA Chicago presentation, let's just assume that it is a B101 owner-architect agreement. The reason why the architect here is orange is because it is an original contractor. It has a contract with the property owner or with somebody that the owner has knowingly authorized or permitted to hire the architect. But the engineering subconsultant that is hired with the C401 agreement is in gray because it is not an original contractor, it is a subcontractor, okay? And the same analysis is true on the construction side. So you, as an architect, under these circumstances, traditional tripartite project where the owner separately hires and separately contracts with the general contractor and the architect. The architect is an original contractor and the subconsultants are subcontractors. Now it gets a little bit more difficult with different project delivery methods. Let's take a look on the next slide at a design build project. All right, so you've got the owner using an AIA A141 to hire a design builder. Or this could be, you know, an EPC, an engineer, procure, construct, turnkey project. Point is that this one entity right here is single source for all design and construction to the owner, okay? It is clearly orange because it is clearly an original contractor. It clearly has a contract with the owner. But now look at the architect of record, okay? It's no longer in orange because there is no line connecting it to the owner. It does not have a contract. And so in this circumstance, it is now like the engineering subconsultant considered to be a subcontractor. It is gray, okay? But consider a design build project where the owner hires a criteria professional, you know, which might be an architect or an engineer that is going to provide performance specifications or maybe bridging documents that the design builder is then going to use to complete, you know, with the project. Here, you can see the line connecting the criteria professional with the owner, and it is orange. And so here you've got maybe one architect hired with a B101, and it is an original contractor. And here you have another architect using the same B101, and it is a subcontractor. And I could throw up 20 other slides like this for 20 other project delivery methods. The point that I'm trying to drive home is that you're either a subcontractor or an original contractor, and the analysis depends upon who you are in contract with. So Casey, do we have a poll here right now for this slide?
Yes,
You know,
we just
so
launched it.
I'd be curious to know, for the people who are out there on the projects where you are most concerned about payments, in order to help me modify this presentation to be most relevant for you, can you tell me whether you think you are an original contractor, whether you think you are a subcontractor, or whether I'm the latest lawyer to annoy and confuse you and you have no idea what I'm talking about? So while we're waiting for those results, you know, without giving you specific information about what the days and the deadlines are, I will tell you that if you are a subcontractor, you have more hurdles to jump through and you've got less time to do it. All right. It's a lot like what I said when I was talking about the owner occupied single family residence. The owner and the developer of any project is not going to know everything about every subcontractor that the GC hired. Just like the owner and developer of the project, they're going to know who the architect they hired is, but they may not know much about the engineering subconsultants. They might not know who they are. They might not know, you know, how much they're owed. And so the law imposes more obligations on you if you are a subcontractor, assuming that the owner just might not know much about you or what you're owed. So if you're a subcontractor, you got more hurdles and less time. If you are an original contractor, you have less hurdles and more time, because the assumption is that the owner or project developer is going to know everything about you. They will have hired you. They will know how much you've been paid. They'll know how much that you are owed. If you are working on a condo project and you think that you may have a problem getting paid, the one bit of advice I will give on this webinar is call your lawyer immediately, because it can take a month or more to get a condo project lien right. And the reason is because in many instances you have to allocate the lien. So you have to say that I'm owed $1 million and I'm putting $76 on parking spot 143. And I'm asserting it against the owners of Unit 3C and their lenders, which are, you know, Wells Fargo, Wachovia, whatever. So condo projects are really complicated for lawyers. And frankly, if you came to me with a week or two before a deadline on a condo project, I'd probably tell you to go find another lawyer, because I'm not going to take you on unless I think that there's a reasonable chance that I'm going to be able to meet your deadline. Mixed use projects where maybe on the ground floor there are office condos, and you know, this business owns part of the first floor and another one owns part of the second floor, and maybe above it there's a hotel or some you know, apartments. Those are also kind of complicated, because the more people that own the property, the more you have to kind of you know, with great precision identify, in most instances, not always, but in most instances, who you're saying owes you what share of the money that you're owed. And again, if you are you know, working on a single family owner occupied residential project, you've got some of the earliest deadlines that are out there. So Casey, do we have any results? Do I know whether most of the people think they're original contractors, subcontractors, or have they all hung up because they don't like to hear lawyers talk?
We had 63% say they're an original contractor, 37% say they're a subcontractor, and 0 said confused with no idea. So
okay, well, some of you are probably just being nice, which I appreciate. So thank you very much, you know, for that. So can we get rid of that box, Casey? That me or you?
I don't see a box.
I'm still seeing the poll that's up there, but maybe when I change the slide, it'll go away. Oh, there we go. Okay, our poll results. Okay, great. So moving along here. Because I thought that a lot of you were going to say that you think you're an original contractor, and I just want to urge you caution, because you know, you think that you know who owns the property, And maybe you're right, but maybe it's not the person that's living in the house that hired you. Maybe it's their great aunt Thelma's revocable trust that is controlled by a trustee that's never heard of you, you know, or maybe you're working on a big commercial project and you're dealing with the developer that, you know, looks to be the owner, but maybe there's a financial partner out there that you've never heard of that controls the LLC that owns the property. And you're not going to necessarily know until a title company goes out and studies the property records. So those old books are meant to be, you know, old property records at the Recorder of Deeds office. You think you know who owns the property, maybe you're right, but maybe not. And you think you're an original contractor, maybe you are, maybe you're not. Don't sleep on your deadlines, because again, if you think you're an original contractor and you wait, and then you go and you hire a lawyer and they do the title work through the title company and you find out you're a subcontractor, you might have a nasty surprise and you might have already blown your deadline. So I did think it was likely that most people would guess that they're an original contractor, and maybe you are, but don't be so quick to make that assumption. And so since we have to worry about things like what I was just talking about, I wanted to run through the process of how you would make a mechanics lien claim. So step one is, you know, you'd consult and, you know, maybe decide to hire a lawyer. And, you know, this isn't exactly a shameless plug for me, but what I will say is that, you know, there are some lawyers that can record liens, and then there are other lawyers that can record liens, and then they can go into court and do battle with the owners and developers and the lenders. And I think you want somebody who can litigate the lien, not just record it, because, you know, the last lien that I recorded on a project in Chicago, it was a commercial building, and it had some eccentricities when I looked at the property records. It had 3 addresses, because it was bounded by 3 major streets in Chicago. And, you know, I was trying to put a lien on the whole building, but, you know, I also knew that there was some argument to be made that maybe it was going to wind up only being on certain floors and certain parts of the building. And so I really wrote that lien with an eye towards someday, if I get a fire-breathing lawyer on the other end trying to tell me that it's no good, what are all the arguments that I'm going to make about the fact that I made my allegations the right way? So having been around the block a few dozen times in these fights, I like to draft these things in a way that I will be willing to myself go in there and put on my helmet and pads and fight for its validity. And so I'd suggest that, you know, if you are owed a small amount of money, maybe you want to find the cheapest lawyer you can, or maybe you want to use one of those lien recording companies. But if you've got any kind of a big AR, I really think that you want a litigator, not just somebody like myself that does litigation and contracts. It's a 1 to 3 day process to hire a lawyer, because after I get in touch with you, I have to make sure that you're not trying to lien a property that is owned by my owner and developer client, because that would be a legal conflict of interest that would conflict me out. And so, you know, I'm tracking dozens of projects right now and hundreds of parties in my database. And so I would need to know who's the lender, who's the contractor, who's the architect. I would need to know all that information. And that's a process that takes a few days, and then you sign up in an engagement letter with the lawyer. It can be done in as short as 1 day, but it can sometimes take a little more. Step 2 is providing information to the attorney. I have a memo that I send to my clients that says, here's all the stuff that I need from you before I can even begin to roll up my sleeves. And it's contracts and proposals and legal descriptions and PIN numbers and, you know, job cost reports that show what you're owed and accounting records and, you know, everything under the sun. You know, it's usually not that hard for you to round up. And at this point, if you are a subcontractor and I can see it clearly, or I believe there's enough risk that you're going to be judged to be a subcontractor, then I am maybe sending out certified mail notices, return receipt requested, restricting delivery to the lender and the property owner, because that's some of the extra hoops that you have to jump through as a subconsultant. Step 3 after you've hired me, I have to go hire Chicago Title or some other title insurer to go out and look at the property records and tell me who owns it. You know, who's the lender, who are the other lien claimants. And I can expedite them sometimes because I've got relationships with really great title insurers. I can get results turned around in a day sometimes, but sometimes it takes longer. And right now in this COVID-19 era, I don't know how quickly they're going to be able to turn those around. But once I get those back, then I got to look at that, and then I have got to draft the document that would ultimately be recorded with the recorder of deeds. Or if you're a subcontractor and I can see it at that point, maybe that's when I'm mailing out my certified letters, return receipt restricted, which is tough because those green postcards, getting them back, I'm not entirely sure how that's going to work out, given that a lot of people aren't enthusiastic about going to the post office these days. And step 5 is you would e-record the lien with the recorder of deeds. And, you know, used to be just a few weeks ago, I could walk into the recorder's office, give them a piece of paper, walk out with a stamped document, call my client and say, guess what, we did it, your lien's on the property. But things are changed now in the COVID-19 era. This is something that was up on the recorder of deeds website the other day. It said, at first what they did is they closed their offices to the public. But they said, go ahead and e-file your liens because our employees will still be here to receive them and look and decide whether they're good enough or whether we're going to be rejected, and we'll record them in the records or not. Recently, it said recording operations are going to cease until the recorder's office reopens. And you can e-file your lien, but all you're going to do is be replaced in the queue. And think about, with interest rates where they are right now, everyone's refinancing their mortgage. Everyone's racing to record mechanics claims. There must be an absolute crush of documents that some employee at the recorder's office needs to eyeball and say it's good enough or it's not good enough, I'm accepting it or rejecting it. And, you know, I don't know what's going to happen. But if you wait until your deadline is, you know, just, you know, a few days away, and you find a lawyer that's willing to take the risk of recording your lien and you e-file it, maybe it gets recorded officially a day later, maybe a week later, maybe a month later, maybe 9 months later. No one really knows what's going to happen. Now, the latest with the recorder of deeds is they figure out how to let their employees from home look at documents and decide whether they're good enough and officially record them. So things are maybe a little bit better than they were when I put this slide deck together, but still, we are in a brave new world of not entirely being able to be confident how quickly we can get these things recorded. And there's all kinds of just other things I worry about. I mean, look, every project is so eccentric. You got multiple proposals and contracts out there. Maybe you've got multiple last dates of work. Maybe someone's going to argue that, oh yeah, you're still good for a $10,000 lien, but that $200,000 lien, that's a different proposal, and you blew your deadline 6 months ago. You know, and then every time I look at track search results, it's an education because every property is eccentric. You know, I worry about my clients mistakenly making assumptions about when their deadlines are. I worry about people who are really subcontractors that think they're original contractors and blow their deadlines. And then all the stuff I talked about in the last slide. What is the recorder of deeds going to do with these documents when I e-file them? Are title companies going to be able to give me track search results? Or with COVID-19, or are they just going to be not able to process the volume? And what about, you know, tens of thousands of people refinancing their mortgage? I don't want my clients' lien claims to be in the recording queue after them. So I've got a whole raft of new concerns here. Good news is that if you missed your deadlines, every rule with mechanics liens has an exception, and every exception has an exception, and every exception has an exception. So it's intensely complicated. In many instances, if you blew a deadline, if no one's prejudiced, you might still be okay in the end. And so here's where maybe I'm going to be able to add the most value. I hope. I only have 5 minutes left in the presentation, but I would be more than happy to continue this conversation beyond the next 5 minutes if Chicago decides they want to leave the Zoom channel open, or I would certainly be able to, you know, and eager and willing to talk with any of you afterwards. So, do you
want to go into the Q&A then, or do you still want to go through the slide first?
I think let me do this first because I'm going to answer Yana some of the Q&A. Okay. So look, current economic conditions. You know, people are worried about cash, and people probably are thinking more about making payroll and certain other things. You know, your owner and developer clients are servicing their loans so that they don't, you know, get foreclosed. You know, and maybe, you know, some of your bills, architects and engineers, are maybe not going to be that important to them right now if they're trying to figure out how to save their business. And so, you know, how big is your AR? You know, if you're a big company that's got $1 million AR, it gets close to a no-brainer to record a lien. $500,000, no-brainer. You know, a few $100,000, no-brainer. You know, I mean, into the six-figure range, low six figures, it's a closer call. You know, if you're between 50 or 100 grand, it gets a lot tougher. And if you're under 50 grand, it gets really tough. You know, I was debating this yesterday with another construction lawyer who I think is actually on this call and is one of the smarter guys that I know. And I said, what do I do with the people that call me up and they say, I'm owed 40 grand, should I lien or not? And it's tough because, you know, if you don't put the lien on there, you're sending a signal to the owner that you don't really care about getting paid. You know, but if you pay a few grand to get the lien put on, there's no promise that they're going to rush to pay you. You know, and you might get entangled in litigation and you might regret it later. And so there are some creative strategies that this, you know, confidant of mine and I were discussing about, you know, maybe you say, look, you owe me 50 grand, I'll take 40. Let me tell you about the upside here is that when you recover that 50 from your client down the road, think about the $10,000 windfall you just had. Or I just, you know, basically gave you 10 grand that you can use to pay your lawyers so you'll get the money that you're owed. There are ways to make those kinds of arguments to look for win-win situations, but certainly the magnitude of your AR is important. Your client payment history is something else that's important. Look, you know, if it's your best client that is always paid on time until this month, that's a little bit of a red flag that maybe they're thinking about where they're going to be putting their cash, places other than paying you. Or maybe you don't know this client at all. Maybe it's the first time working for them on a project, or maybe you've got some concerns that maybe they have a loan to acquire the property and to get the, the SD and the DD work done necessary to go and apply for a loan, but they don't have their construction loan yet. Boy, you know, maybe I'm getting worried about that client's ability to pay. Then there's relationship considerations. You know, nobody wants to anger their best clients, but, you know, like I said, in my opinion, any developer or property owner that would be overly upset with a design professional that acts prudently to meet their deadlines to secure their claim is probably not being very fair to the design professional. So there are ways to kind of tell your clients how much you love them, and you're really just being prudent because you have to think about your employees and things like that. And then again, if you are an architect that owes substantial money to consultants, boy, I wouldn't want to be past your deadline to record a lien and get sued for a few $100 grand by your subconsultants, because those claims may very well be valid and they may very well be killers for your firm. So if you are an original contractor and you are worried about the money that you owe downstream, that is a powerful incentive to make sure that you do everything to get paid. Then there's the hassle and the expense. I was pretty anal and detail oriented before I went to law school, but it really took it to a new level when I went to law school. And I'm going to be pushing you if I'm working with my clients on, I want to know what you did on the last day of your work there. I want to know if it's enough. I want you to prove it to me. How many hours? Could you charge for it? Or were you just doing some nonsense punch list work, you know, that isn't really valuable? I might put you through the ringer because I've got to do my due diligence ethically, because before I can encumber somebody's property with a lien claim, I got to do everything I can to make sure that I'm satisfying my ethical obligations. And so, you know, we'll laugh and joke and have fun, you know, and I won't annoy you too much, but no one likes to work with lawyers. And I like to think that I'm different, but, you know, maybe not. And the last part of this is just tolerance for risk. I mean, and here's where there's an element of business judgment where I just can't counsel you on. Some people, when they go to Vegas, they go to the high stakes tables because they're risk takers. And other people, they go to the shows and they don't gamble at all because even putting a nickel on a slot machine is more risk than they want. I can't answer that question for you. You know, only you can decide. How much cash do you have on hand? Are you worried about making payroll? Are you willing to invest in what might be the least expensive way to increase your leverage? €20,000 or €30,000, and maybe accountant and saying, if I write this off, do I get a tax benefit? I mean, I just don't know. There's so many business decisions that I can't counsel you on. But you know what, construction lawyers like me, and there's a whole bunch in Chicago, you probably all have your usual lawyers, and they know as much about this as I do, and you should talk to them about it. They can help you spot issues and think about the things to consider when you are wrestling with the difficult decisions that a lot of people like me and you. I am a professional services provider like you. I've got a lot of the same concerns as you do. We have to make these decisions for ourselves, and your usual lawyer is going to be as well equipped as I am to help you. I'm not trying to step on their toes. So that's the end of my presentation, and if there's any Q&A, I'm happy to take questions with the caveat that for all I know, you are owed money by my clients, and I am not going to give anybody any specific advice that they might use to put a lien on my clients' properties, because I don't want to lose my law license. I would be delighted, you know, to have brief initial conversations at no charge with anybody who's on the call. But if your questions are specific about your project, for a variety of ethical reasons, I'm not going to be able to take them right now. So with that, you know, let's fire away, Casey, Yana. Anything I can do to answer questions, I'll certainly do that.
Yeah. So Jeremy, we see a couple of questions here that relate to the same topic, and they're not relevant, maybe they're relevant always. They're about the submission of waiver of lien with the original invoice prior to architects actually get paid. And that's obviously a topic that I think all of us are very familiar with, where we sign off on our ability to place a lien before we even receive the payment. So what would be your advice on that?
This issue has been the topic of a ton of litigation, and if I printed out all the court cases where a judge weighed on this, it would stack from the floor to the ceiling. So I don't want to give an overly simplistic answer, but the short answer is that the courts are well aware of the common practice of having to submit advanced lien waivers before payment is received, and in many instances, you're not going to be tied to it. You know, if you give a lien waiver and, you know, with a payment application and you never get paid, and the owner or developer thinks that they are going to go, ha ha, I tricked you, I've got your lien waiver. And most times they're not going to they're not going to win that argument. There are exceptions. I mean, the thing about the payment applications and the sworn statements and the lien waivers that are commonly provided, you know, every month by all of the people that are on this call is that the owners have to look at that and then make judgment calls based upon what they see on how they should conduct themselves, whether they should be paying the general contractor or the architect that's in contract with the owner, or whether they need to pull back and start making direct payments to some of the sub-consultants and subcontractors. If you put false information in the documents that you submit, if you swear that you have in the past been paid more money than you really have been paid, okay, in a sworn statement, that's when you might have a really bad outcome. But if you're just handing over a lien waiver that says that this payment, 25 grand is what I'm asking for, this is what I'm getting, and this is how much my balance is going to go down once I receive that, you're probably going to be just fine, you know, in lien litigation, with the caveat that every rule has got an exception, and that is an exception, and that is an exception.
Another question we have here is public projects and how liens can be applied there.
Was that public projects, Yana?
Yeah, public projects, yes.
So the difference is that, and this is one of those things that I think, you know, people that don't spend a lot of time thinking about liens will understand instinctively. You know, if you're helping a developer build a private project, there's no public policy reason why a court shouldn't sell it to make sure that you're paid. But if you're designing a school, you know, it's really bad for the school district if the architect goes into court and gets the school sold, because the school or the hospital or whatever public facility it is has been funded by taxpayer dollars, and it provides an essential service. So in the world of public projects, your lien does not attach to property, and you don't sell the property in order to get paid. What your lien attaches to is the money that the public entity has set aside specifically for that project. And here's the rub. When the money is gone, it's gone, okay? And so your deadlines are different. They're not necessarily queued off your last date of work. But if you on a public project do not make your lien claim before the public entity has paid out all the money that they have set aside for the project, before they put it into the hands of the lead design professional that's in contract with the owner, or before they pay that money out to the GC, once the money's gone, it's gone. And so there's a raft of different considerations. The way that you make lien claims are different. They're not recorded in the property records. And frankly, it's much more arduous to make public lien claims than private. I can slap a private lien claim on a piece of property relatively easily and let it sit there for a few years, and maybe my clients get paid. In the world of public projects, if you file a lien, I can't remember the exact deadline, but I think it's something like 90 days where you have to rush into court and file suit, or you lose your lien. And so it's just a different universe of considerations, and it's harder and it's more time sensitive to make lien claims on public projects than private.
You see here, we have still several questions. So Cyrus is asking, he would like to hear a little bit more about the 30-day letter, and if the lien amount does not just justify litigation, and a 30-day letter is served, what is the value of the recording a lien? What can be done if a 30-day letter is received?
Well, so there's a couple things here, and I can address them all. I'm not entirely sure which one of two questions is being asked, but there is a provision under the Lien Act, Section 34 of the Lien Act, which allows owners, developers, lenders, tenants, people that are on the receiving end of a lien, don't like a lien, to say, okay, architect, you've recorded your lien claim. Okay, contractor, you've recorded your lien claim. I demand that you file suit on that lien claim within 30 days. And if you fail to do it, once you are in receipt of that kind of a letter, then the lien it's invalid. And that's why what I said in my earlier slide, that on a private project, a lien claim is usually good for 2 years. I said usually, because you know, the owners on the receiving side of the lien claim, the tenants, the lenders, they can force you to put up or shut up within 30 days, and then your lien is wiped off the property. So that's one thing. Another question, and I don't know which one is being asked exactly, but I'll address it anyway, is a lot of people hear about the 90-day notice that subcontractors have to give. It's one of the hurdles that subcontractors have to leap through that original contractors don't, because again, subcontractors are not necessarily, the owner isn't necessarily going to know the identities of all the subcontractors, trade contractors, whereas they do know the identity of all the original contractors that they're in direct contract with. So in Illinois law, if you are considered a subcontractor, and again, it's binary, you are either an original contractor or you are a subcontractor, one or the other. If you are a subcontractor, the law requires you to send a letter, and the requirements for the letter, the form is pretty simple, but the requirements for how you transmit it are not. You got to send this notice It has to be return receipt requested. I believe it's like certified mail, but not registered mail. It needs to be delivery restricted to a specific recipient, and it needs to get to them and say, hey, I'm a subcontractor on your project. I've not been paid, and I might have a lien coming your way. And that gives the owner, the lender, the time to say, okay, let's get this person paid. So there's a lot of upside for sending in these 90-day letters because it helps sometimes to get you paid without the trouble of taking the next step, which is actually recording the lien document with the Recorder of Deeds office. But if you don't send that 90-day letter and you are a subcontractor, you're probably not going to have a good outcome in lien litigation. Your lien might not be valid. So that the 90-day letter is a requirement for subcontractors, and it's something that you should absolutely do if you think you're a subcontractor and not an original contractor. Original contractors don't have to do that. Original contractors just have to record their mechanics liens within the deadline that's required of them, and it's a little bit longer than that 90-day period.
So as we have only 3 minutes left here, I have one quick question that I see several people are asking is, can you as an architect ask for the legal information as to who actually owns the site? And is there kind of like a preferred way to do that prior to even signing a design services contract?
Well, you know, it is standard language in a lot of the AAA agreements that that you're allowed to request that the owner, you know, provide that information to you. And here's where I will get on my soapbox just a little bit here, and hopefully not anger too many architects. Most times I'm not talking about mechanics plans. I'm talking about this now because of COVID-19 and the strange times we're in right now. Most times I'm talking about how if you want to avoid disputes and get paid and have good outcomes, you should invest in good contracts. You shouldn't send out proposals that don't have terms and conditions on the back. You shouldn't sign whatever piece of garbage contract the owner hands over to you, because if you invest in having good contracts, you will have good outcomes. You'll have contracts that say that if you don't get paid, you're allowed to stop the work. You'll have contracts that say that if you don't get paid, the owner's not allowed to use your intellectual property. You'll have contracts that say that you can go quick and simply in a mediation or arbitration and skip more expensive litigation. And you'll have contracts that say that if I ask you to give me the name of the owner or the PIN number or the legal description, it might be included, it might be an obligation for the owner. But, you know, if you go right now and you say, hey, owner, I kind of want to know who the real property owner is because I want to lien your project, you probably can expect radio silence. And that's the reason why there's a time aspect of this after you hire your lawyer. I know how to look at the Recorder of Deeds website. If you can get me the PIN number, the property identification number, the tax number, I can probably find out a heck of a lot about the property. And if you can't, if you could tell me who you think owns it, you give me the address, some other information, I could probably dig around and I can maybe figure out the PIN number. And usually what I do while I'm waiting for the title company to give me their results, I'm on the Recorder of Deeds website doing my own due diligence because I want to see not just who signed the deed, but, you know, it's one LLC that's the manager of the other LLC that's the manager of the other LLC. It's got all these signatures and at the bottom of the document, and that allows me to learn more about what I might want to put in your lien. So the short answer is that learning who the real owner is, learning what the property identification number is, the PIN number, learning what the legal description is. There's a bunch of different ways to do it, and there's a chance you might be able to do it on your own. But probably you're going to want to talk to a title company, and preferably a lawyer that would then talk to the title company. You can ask the owner, but you know, it's kind of like pouring gasoline on them and lighting them on fire and saying that I got a claim coming your way. So there isn't always a ginger way to do that.
Well, thank you, Jeremy, for your time, and thanks for everybody that joined in. I think, Casey, that's the time we're going to end the Zoom meeting, correct?
Yes, and we'll, we being AI Chicago, will make the recording from today available to any attendees as well. and get that out as soon as we can.
Thank you all. Stay safe.
Thank you, Jeremy. Thanks, everyone. Take care.
Thank you.
Bye-bye.